January 2017, Year Zero, when a household's frame loosens. There are moments in a life that read like ledger entries, crisp dates, stamped envelopes, signatures that resolve a question into a line item. And there are moments that refuse to be counted, memory, affection, resentment, the small gestures no contract can measure. This is a story that moves between those two kinds of knowledge. It is not a neat moral parable. It is a chronology of choices and consequences, of paperwork and soup, of attorneys' letters and neighborhood intake workers, of slow decline and hurried practicalities. I will mark it by seasons and years, and by the practical phases that mattered, the dispute that widened a household's frame, the months when community programs kept us afloat, the years that reshaped grief into daily obligation, the weeks of caregiving before death, and the long tail of probate and practical labor afterward. If you want the lesson at the outset, paperwork can wound and protect in equal measure. Presence, ordinary, small, patient, also matters. January 2017. The sharp first cut came in a way that, at the time, felt mundane, a disagreement about money and responsibility that could have been repaired at the kitchen table but instead was translated into legal form. A letter arrived, then another. Someone had decided to put grievances into typed sentences and request signatures. An attorney's envelope converts domestic speech into a different register. It confers an official weight on what had been, until then, ordinary irritation. Where there had been rooms for negotiation, there were now clauses. Where gestures and apologies might have sufficed, there were signed demands. The moment the first envelope arrived, the tone of the house changed. Ordinary acts, who took out the trash, who answered the phone, who offered a tired smile at dinner, took on a heavier subtext. The legal paper did more than state a claim, it reshaped the terms of living together. January-June 2017, months 1 to 6, the quiet work of community. In the first 6 months after that envelope, when grief and anger and resentment felt raw, we were kept upright by people who did their small, quiet jobs well. A neighborhood social program, an intake office that had mattered to my brother before, turned out to matter in a less dramatic but no less consequential way. The intake workers were not heroic figures in any obvious sense. They answered phones, filled forms, kept waiting lists, explained eligibility criteria. They argued in the break room and missed deadlines sometimes. But their competence mattered. One intake worker took a complex, confusing notice and translated it into plain language. She wrote a phone number in a tidy hand, called the contact herself, and suddenly the possibility of eviction, which had hovered like a vague threat, became a sequence of next steps. Community resources are prosaic by design. Forms are bureaucratic, funding inconsistent, eligibility rules sieve-like. They admit some needs and deny others. Yet when family scaffolding fractures, they form a patchwork that keeps people upright. I remember, on a sleeting afternoon in March, standing by a window while she explained a modest benefit that might delay eviction for a month. It was not a permanent solution, it was a rope thrown in a storm. It required persistent calls, weary documentation, and the willingness to follow up. That intake worker's translation, clear words, a neat telephone number on a scrap of paper, diverted catastrophe for a while. Those acts of translation and follow-through were political and human goods, small and relentless. There is a history to why such programs matter. Over decades, cycles of public spending had thinned the nets people once relied on. The labor of navigating the remaining structures fell on those with the least capacity for paperwork. Our luck with one calm intake worker was not simply personal. It was institutional, someone doing the job the institution still expected in a moment when social supports were fraying. Each small act of bureaucratic competence felt like a bulwark against a wider unraveling. 2018, Year 1, Learning to Live with Avoidance. By January 2018, the sharpness of that initial injury had dulled, not because wounds healed cleanly, but because life insisted on other demands. Jobs needed doing. Children had recitals and colds. A neighbor died suddenly and the block paused. A heavy snowfall in February forced us to clear sidewalks and buy milk. These ordinary pressures centrifuged grief and anger toward the edges of daily life. The past did not vanish, it changed where and how it pressed against us. We learned, by necessity, to treat certain topics as fragile. Some subjects we no longer opened unless we had to, some memories felt like glass panes that might shatter if touched. This avoidance was not dishonesty but a practical decision. Do not invite further ruptures into a household already straining under legal formalities. Sometimes the avoidance looked like gentleness, choosing not to ask about the particular phrase that had led to a letter, or straightforwardness, agreeing to tasks without rehashing old grievances. The home became a space of selective disclosure, rooms of memory kept closed, others aired when needed. The practice was functional, not ideal. Forgiveness in that year was not a sudden surrender but a sequence of small decisions. I forgave by how I answered a phone call, by bringing a bowl of soup, or by failing to bring one. Sometimes the magnanimity felt genuine, sometimes it was diplomatic currency. On some afternoons I felt large enough to be generous toward my father, on others the sight of a signature again felt like a fresh sting. Forgiveness is an arithmetic of increments, not a single stroke of absolution. 2019, Year 2, Levity, Care, and the Limits of Law. Throughout 2019 my brother's liveliness helped carry us through many afternoons. He had a way of repeating an old, ridiculous story until it was funny again, and for an hour the weight of loss lightened. Seeing him laugh did not erase harm, but it kept contradiction tolerable. People who could do wrong and yet, in small clumsy ways, be sincerely kind. That year also taught us the limits of legal instruments. The law can create enforceable obligations. It can adjudicate and sanction. It cannot sit at my kitchen table and perform the daily, messy ledger of mutual accounting that keeps a home functioning. The tacit rules about who picks up a child from school, who pays which utility, who covers the morning grocery run when someone is ill. When families can speak plainly about expectations, what each person can and cannot do, they create an informal, living document of promises that statutes cannot. When mediation failed, the courts stood ready to draw sharper lines. Each step had costs, relationships, time, dignity, and sometimes those costs exceeded the monetary stakes. Yet sometimes legal action was necessary for safety or urgent need. Late 2019, months of care and decline. In the years before my father's decline became terminal, forgetfulness accumulated like slow erosion. Missed appointments, garbled phone conversations, a name forgotten and then arrived back like a misplaced object. I learned to make the calls soft. I stopped pressing for hidden wounds every time memory slipped. I listened to complaints about the weather and kept silence in the small stumbles, because sometimes in the middle of a flubbed sentence, a photograph of a grandniece would arrive and the ache would briefly turn tender. By autumn 2019 doctor visits multiplied. Medications were adjusted as conditions evolved. Conversations about hospice, what it would mean and when it might be appropriate, were held in clipped, practical tones before grief could frame them fully. Refrigerators filled with food no one could stomach, schedules were rearranged so my brother and I could take turns sitting with him. Sometimes the silence between us was companionable, at other times it was thick with unsaid things. The lawyer's calls, once frequent with formal demands, mutated into messages about probate timelines, forms to be signed, and documentation needed for future claims. Winter 2019, death and the first phase of labor. My father died in winter 2019. It was neither cinematic nor sudden. I remember the light in the room like suspended dust, the small mechanical sounds of the house. The days before his death were a spool of narrow tasks, the days after required a different kind of labor. I became executor of his estate. The title suggested dignity, but in practice it meant an unending list of obligations. Bills to settle, accounts to close, a house to ready for sale, objects to return, others to distribute. I handled intimate paperwork, tax returns revealing unexpected habits, policy documents on thin paper, receipts for repairs I had not known about. There were small embarrassments, a credit card charged for a recurring donation he did not remember, a subscription left on autopay because it once seemed harmless. Sorting these items was oddly merciful. Practical labor in that first phase after death postponed a knotty, raw mourning that had no inventory numbers. The will and the trust. The will, as executed in probate, reflected negotiations that had been unfolding quietly over previous years. My father had set aside a modest trust for my brother, intended to cover rent and cushion emergencies. It was not a structural correction for the systemic insecurities that shaped my brother's life. It was meant to prevent immediate displacement and avoid repeating earlier harms. My father also left a small donation to a neighborhood nonprofit he supported in his later years, an organization that ran children's classes and a modest food distribution program. That donation felt like an attempt to broaden belonging beyond our household. It was a gesture that married private care to a public-mindedness he had practiced quietly. Most of the remainder of the estate was to be sold to cover medical and funeral expenses. Whatever surplus would be divided between my brother and me. On paper, the estate administration looked neat: line items, invoices, receipts. In practice, the aftermath was messy in ways numbers do not capture. Insurers required documentation for claims. Creditors surfaced. The lawyer who had once hardened family conversation into legal posture submitted a final bill that made my mouth go dry. He had performed legitimate work, filings, calls, last-minute clause clarifications, but the total felt disproportionate. We discussed whether the fees were reasonable and whether earlier actions had compromised his impartiality. We did not litigate his bill. The cost and energy would have exceeded the amount at issue. Still, paying it felt like an extra wound, money exchanged for a kind of silence that could not be bought. Spring 2020, the house is sold. The house sold the following spring. The real estate agent staged rooms with a considerate neutrality. Fresh paint covered years of small, unremarkable tragedies, scuffed walls, a faint halo where a plant had sat for a decade, a thumbprint in varnish I could not bring myself to sand away. The division of objects was pragmatic. My brother claimed a small table whose drawer still smelled faintly of paper airplanes. I kept my father's reading lamp and the chair where he had sat for long afternoons. Boxes of clothing and a collection of ceramics were donated. Some items resisted disposal, letters folded with meticulous care, postcards from trips my father never fully described. Those went into a box I have not opened without hesitation. It sits on a high shelf. Passing it feels like entering a room where a storm has passed. Charged air, furniture subtly rearranged. 2020 to 2021, the trust and a measure of stability. In the year after the sale, the trust functioned as intended. It covered rent in difficult months, paid for a car repair, purchased a toy for my brother's daughter. My brother found a modest apartment near a playground and a laundromat whose attendance proved steady and kind. Renting softened precarity's edges, it did not eradicate it. Years later he remarried, slowly and quietly, to someone who did not require him to unpack every detail of his past. They established domestic routines, dinners, morning rituals, small tolerances, and at family gatherings he laughed in a new measured way. The aftermath, contested memories and quiet boundaries. Even after legal instruments were executed and the house sold, the shadow of paperwork remained. An aunt resurfaced claiming my father had promised her something decades before. A contractor disputed a repair that had been authorized informally. These episodes reminded us that a life's contours can be contested after a person dies. We established pathways for dispute, reasonable offers when possible, transparent records of payments and authorizations, and the willingness to walk away when the cost of insisting on legal rectitude exceeded the value of the outcome. Choosing not to litigate every grievance became a central tool. Strict justice sometimes costs more than it cures. Practical lessons in preparedness. These experiences altered how I regarded the mundane legal chores people defer. I became careful about durable powers of attorney and healthcare proxies. I drafted written agreements for temporary stays, who pays utilities, who may assume residency, what to do in a short-term caregiving emergency. These documents were not grand gestures, they were acts of care folded into administrative form, a letter of expectations for short-term caregiving, a durable power of attorney entrusted to a friend both siblings trusted, a clear statement about medical decision-making in the event of incapacity. They are not guarantees, only modest attempts to prevent decisions from being invented at the hour of crisis. Alongside paperwork, ritual mattered. On the first anniversary of my father's death we gathered, small, necessary, awkward, and ate a simple meal in a living room still adjusting to his absence. There was no cinematic reconciliation, no cathartic purge. There was acknowledgement and modest recognition of the small acts that had kept us afloat. My brother's daughter drew pictures and used star-shaped magnets to affix them to the refrigerator. For a few hours the past softened and ceased to press the room into sharp, unkind angles. It was a respite, not a cure, but enough to sustain us for the months ahead. Context, cultural and structural forces. Our story is not a single, simple narrative. To some it looks like a cautionary tale about material concerns eclipsing affection, to others, a tale of failed filial duty. It is both and neither. It is a story about processes, legal, social, emotional, and how they interact with the soft, messy elements of the heart. Legal instruments can dispossess and protect in the same breath. The effect depends on who wields them and why. There is a cultural tendency to frame litigiousness as a personality trait rather than a sequence of decisions born of scarcity and fear. When the difference between keeping a roof over a child's head and losing everything can be measured in weeks, legal battles feel necessary, not elective. That is a structural observation with ethical implications. Judgment is easier from the outside when you are not the one keeping vigil over unpaid bills. Memory and the limits of paper. Family stories are edited constantly. People omit details for convenience or to soften a remembered past. They emphasize some moments and minimize others. A letter can lock one version of events into the record, but it does not fully rewrite memory. Memory lives in bodies as much as on paper. Who sat at a bedside during the hour that mattered cannot be recorded in a will. The law assigns legible rights to certain claims. It cannot model the warmth of someone handing you medicine in the night. We reinvented our ways of measuring what mattered, not in great absolutes of redemption or damnation, but in small, concrete actions. Who brought cold medicine, who sat quietly for an hour with an uncommunicative man, who walked an application to a mailbox for someone too shy to enter the office. These acts are often invisible to systems that privilege signed contracts over soup, but they carried value that the legal record could not capture. Practical recommendations. If pressed for a single practical takeaway, I offer this: do the small paperwork now. Draft a durable power of attorney. Have the healthcare proxy conversation in your living room over tea, not in the heat of crisis with lawyers on speed dial. Write a succinct note explaining who will manage what if something happens. Make arrangements legible to a stranger who may one day have to administer them. Keep receipts and a clear record, not to weaponize, but to prevent disputes over what was said or done. And crucially, cultivate the habit of attention. Call your sibling on ordinary days. Drop off soup when someone is ill. Ask about a child's school play and listen as if learning a new language. Attention accrues interest. Holding contradictions. I have learned to live with contradictions. The lawyer who drafted the earlier letter was, technically, effective at navigating probate and filings. Yet in my view he failed to translate legal language into human terms. That failure is the verdict I return to when I tally his help and harm. I can value the trust my father established for my brother while recognizing the social conditions that limited my brother's opportunities. I can admire community workers and also see how precarious their roles become when funding thins. Holding these contradictions is realism, not evasion. Small amends and everyday repair. Privately, I practice small, practical amends. I call my brother on days that are not holidays. I drop off soup when he is ill. I ask detailed questions about his daughter's school and listen with the kind of focus that turns presents into a gift. He forgives in ways I do not always deserve and forgets in ways that can feel merciful. These small continuations, phone calls without agenda, soups left at the threshold, shared silences, are the work that shelters us toward better practices. My hope for cultural and institutional change is modest and practical. I hope mediation becomes normalized as a cost-effective tool to prevent needless escalation, not an indulgence only available to those who can afford it. I hope legal instruments are drafted with both precision and generosity, language that protects without hardening the contours of relationship unnecessarily. I hope families talk sooner about expectations and responsibilities, and that they put those conversations into words others can understand without a lawyer's translation. What endures? When I stand in the empty room where my father slept, I find no tidy moral beyond the stewardship of small acts. Sometimes I plug his lamp in and sit with the light until the space feels like a conversation again. The documents remain in a file, signed, witnessed, inert and alive at once. They remind me that words on paper can wound and can protect. What finally matters is less the cleverness of a clause than the steadiness of the commitments we make to one another while we are still capable of making them with even a sliver of love. Practicalities, even now. I keep duplicates of important documents in a small metal box: passports, insurance policies, a copy of the will, durable power of attorney and healthcare proxy forms. There is a list on the refrigerator detailing who pays which utility and where to find receipts. These are not grand preparations for catastrophe, they are small kindnesses. They are the extra word that says, "I thought of you." Their purpose is to ensure that the first instrument someone encounters in shock is not a lawyer's letter. Certain scenes return with stubborn clarity: the intake worker whose calm bluntness untangled a bureaucratic knot, the hospice nurse who spoke patiently about how the last days might unfold, the staging agent who arranged neutral curtains and a bowl of fruit and made a house feel like a place someone could imagine living. These professionals were not saviors. Their competence mattered. It made a difference. Alternative endings and practical hopes. Sometimes I replay alternative endings in my head: a letter never sent, a conversation that might have been different. These thought experiments are useful but not blueprints. Life resists tidy rewrites. My practical hope is modest: people will prepare both the legal and human aspects of care. Organize your affairs so they are legible to a stranger who might one day administer them. While the living are still speaking, use language others can understand without a lawyer's translation. Have hard conversations sooner rather than later. Plan for mediators and compromise. Keep clear records, not to weaponize, but to prevent future disputes. A final, simple prescription. If I could leave one instruction in a single sentence, it would be this: paper matters, and so does presence. Make your arrangements clear on paper, and then spend your remaining days practicing the gentler, harder work of being present, in errands with soup, in phone calls that do not demand an immediate outcome. Legal instruments will protect certain things. The rest of us are left to safeguard our relationships. In that daily, ordinary tending there is the true shelter. We did not become a perfect family. We became something less tidy but truer, practiced at tolerating one another's imperfections and persistently, inelegantly, trying to make a future that held less of the particular harm we had known. There are mornings when a letter slides from the file and I read its crisp injunctions and remember how formal language can harden feeling into a claim. There are evenings when my brother calls and we talk about nothing and everything at once. These small continuations, phone calls without agenda, soups dropped on doorsteps, shared silences, are the practice that shelters us. This narrative is not a moralizing tract. It is a historical sequence of ordinary acts, legal and otherwise, tied by the stubborn fact that people, even when they are hurt, keep trying. The law is an instrument. Its effects are determined by the hands that wield it. The everyday acts of care, forms filled out patiently, a worker who drags your file to the front of the stack, a neighbor who shovels your stoop, a sibling who shows up with soup, are what let ordinary households survive when legal instruments harden or fail. Arrange your paper. Cultivate presence. That two-part practice carried us forward. June 12, 2018 is the date I think of when I measure the sequence that followed. On that afternoon my father stopped speaking in sentences and began to sleep as if he were reading something that only he could see. We buried him 10 days later. The funerary calendar, weights, signatures, chairs rented and flowers bought, made the immediate following weeks a mosaic of small obligations. By July there were more prosaic tasks: notifying banks, canceling subscriptions, sorting the shed, and opening the probate packet the lawyer had given us. Those tasks are the ones that insist on being finished first. The lawyer's first letter arrived in early September. It was a lean, formally worded document, 2 pages, signed and notarized, addressed to my brother and his wife. Its core sentence read, "Vacate the room within 14 days." It cited the instrument on which it relied, the trust instrument my father had executed in March 2016. In the same breath it described how possession, once peaceably surrendered, would not be contested if returned promptly. The letter was an invitation and a threat. That blend is how legal prose often works. My brother and his wife had been staying in my father's house intermittently for over 3 years by then. The arrangement had been flexible because that is how families often survive in precarious labor markets: a sofa, a spare room, a stopgap. My brother had been unemployed, their combined income irregular. My sister-in-law taught part-time and picked up evening shifts when she could. The house provided a margin of safety that allowed them both to take scarce, unpredictable work. The lawyer's letter did not heed the difference between possession that is legal and dependence that is necessary. It was dated September 4, 2018. Within the calendar of our family grief, it felt like an outside clock applied to an internal ache. There was a hearing scheduled on September 20th. The lawyer, representing the estate, insisted the trust's terms were clear. The property reverted according to the decedent's express directions, to be distributed or liquidated as stated. It is useful to be precise here. Trusts are instruments of instruction. They name beneficiaries and trustees, delineate powers, and set triggers: death, incapacity dates. In this case, the trust named my father's niece as primary beneficiary and appointed an independent trustee. The document's language left no operational ambiguity about title. But title and tenure are adjacent but not equivalent. Having legal title gave the trustee and the lawyer the right to remove occupants. Whether they should have exercised that right in the midst of a family's dislocation is a moral question, not a legal one. At the hearing, the trustees' counsel produced a notarized inventory and an affidavit asserting immediate need to secure the property. Their argument stressed exposure to liability, deterioration from unpaid utilities, and the need for a swift sale to pay outstanding debts and property taxes. My brother's counsel, he had managed to find a legal aid attorney on a pro bono panel, argued mitigating factors: informal tenancy, equitable considerations, the impracticality of finding new shelter in the coming winter. The judge, bound by the statutory grant that gives trustees broad discretion to manage real property for the benefit of beneficiaries, granted a temporary order allowing the trustee to take immediate possession, with a return hearing set for October 15. What followed was not, as some in our family had imagined, a well-orchestrated eviction with forms and a marshal. It was a day in late September that began with a polite knock and ended with a changed lock. The movers arrived with a list and receipts, an inventory checked against the trustee's schedule. Items were labeled, boxed, and carted away. My brother and his wife stood on the porch and watched their life be placed into U-Haul boxes. There was a small, urgent pleading in my brother's voice and a legalistic placidity in the trustee's face. The letter the lawyer had written had, in effect, translated into action. A family cannot undo the mechanics of law with grief. There is an immediacy to possession. If you do not hold the keys, you are practically displaced. My brother, his wife, and their 4-year-old daughter, her name in our house was already a marker for small, cheerful interruptions, spent the first week in a hotel my aunt could afford for them. The hotel served as a temporary stabilizer while we scrambled for options. Habitable shelter would soon prove to be scarce. The local shelter intake had a waiting list, and the Housing Authority voucher program required documentation they did not possess and time they did not have. The trustees' counsel had calculated for the speed of sale. My brother's counsel had calculated for the probabilities of relief. Neither had value enough for the other's timeline. We tried mediation. In October, on the 15th, the return hearing took place in a crowded courtroom whose well-polished benches smelled faintly of must and old coffee. The judge heard the parties and, recognizing that the trust's grants were not ambiguous, refused to reverse the earlier order to allow the trustee to prevent obstruction to sale. He did, however, offer a narrow measure of discretion, a stay for 30 days if the trustee could show imminent harm to the property. The trustees' counsel promised to consider a short-term lease but immediately followed up with an offer to contribute 2 months' rent to a housing fund as a form of relief. It was a sum meant to be magnanimous on paper and inadequate in practice. 2 months' rent in a high-cost urban market buys only time, not stability. We learned the mechanics of displacement with a painful specificity: how housing offices calculate income, how shelter-matching algorithms prioritize families with documented vulnerability, how local landlords require credit histories that are thin for workers in the gig economy. By November, my brother and his wife had moved into a sublet in an older apartment building 2 neighborhoods over. The place was small and damp and offered a single contract, It lacked the privacy and permanence of the house. Their daughter came to us on weekends and for sleepovers. These hours became our saving rituals. The lawyer's role in this history deserves close analysis. His letter, his filings, his counsel to the trustee followed a professional script: protect the trust, marshal assets, avoid liability. In those tasks he was competent. Failure, if there was one, was not in legal competence but in social translation, the inability or unwillingness to temper strict legal remedies with alternatives that would preserve human stability. That is not a fault unique to him. It is a systemic tendency in which legal instruments are mobilized to protect value in a market sense while social value, caregiving labor, small economies of mutual aid, remains unpriced and unprotected. There were other episodes of law intersecting with human lives in those months that illuminate the structural backdrop. The Housing Authority, which in June 2017 had reduced some emergency funds by a reallocation, had a waiting list that lengthened with each fiscal tightening. Local non-profit legal clinics were underfunded. The pro bono attorney who represented my brother was, by the client's own report, devoting unpaid hours because the calendar would not otherwise have allowed it. I found myself keeping a ledger of dates: September 4, 2018, vacate letter; September 20, preliminary hearing; September 27, locks changed; October 15, return hearing; November 2, move to sublet; January 10, 2019, appeal denied; March 12, 2019, housing voucher denied for lack of documentation. Dates stitch this narrative into a sequence that clarifies causality. The legal steps did not exist in a vacuum, they intersected with policy choices and resource limitations. What saved us intermittently were small acts that the law cannot order: neighbors who gave away a couch for free, an intake worker who expedited a social service form on a slow morning, a church that offered a one-week lodging voucher when the temperature dropped to record lows in December. We accepted what help we could, which felt like an admission of dependence and a gratitude at once. My brother's daughter began attending a different preschool. The administrative transfer took 3 weeks and 2 separate signatures, and in those weeks we worried about continuity of care. By early 2019, we had cultivated a different daily routine. My brother found part-time work at a warehouse that paid more consistently, though it offered fewer hours. His wife picked up evening shifts at a deli. Their income was enough to keep them out of shelter, but not enough to qualify for many subsidized programs. The house, meanwhile, moved through the trustees' processes: an appraisal in December, a listing posted January 9, 2019, an accepted offer February 1. The sale closed on March 5. These are prosaic details, but they are also the way the law translated paper into outcome. Ownership changed hands. Money exchanged. The legal system performed its tasks. We had, intermittently, opportunities to imagine different outcomes. At one point the trustee's niece, the beneficiary named in the trust, offered an out-of-court arrangement: a small equitable payment in exchange for my brother's cooperation during the sale, plus an agreement to prioritize his family in any potential buyback. The attorney shepherding the transaction advised that such an agreement would complicate the trustee's fiduciary duty. Trustees are legally constrained from preferring one creditor or beneficiary over another. Their duty is to act prudently and to document their decisions. The niece's offer, generous as it was in sentiment, could not be squared with the trustee's obligation absent a judicial imprimatur. Even acts of goodwill must navigate the architecture of legal duties. Memory records moments differently from court dockets. My brother remembers the day he stood at the kitchen sink and wrapped a dish towel around his daughter because she was shivering while the movers took her stuffed animals. He remembers the neighbor across the street who brought over a box of cereal and sat with him on the stoop until midnight. I remember, with an odd clarity, the trustees' council reviewing the inventory and marking an antique clock as estate property, the same clock that had been wound each Sunday morning for 30 years. Objects acquire narrative weight. The law registers objects as assets, family registers objects as repositories of memory. One practical lesson became evident: informal occupancy without documentation creates vulnerability. Landlords and trustees alike act on the measure of legal record. If someone occupies a property without a lease, their rights are limited to what equitable doctrines might afford, and equitable relief requires time and resources most families do not possess. My brother lacked receipts for rent payments made in cash, He had not been added to utility accounts. He had not been on a written lease. These omissions are common and often innocuous until they are not. They explain, in part, why the lawyer's letter had so much bite. Throughout 2019 we rehearsed another set of small repairs, repeated phone calls, dinners delivered, rides given, and an unending patience for bureaucratic forms that our relatives found habitually annoying. My brother's daughter, whose drawings had become a household ritual, kept a picture on our refrigerator with the words, "Family is more than walls." She was 5 then. Children voice a certain truth that adults wrap in policy and plea. The historical frame narrows when one considers the broader housing context of our city. Between 2010 and 2018 rental rates had risen by approximately 42% in the neighborhoods where we had lived. Social housing funding had tightened in 2016 after state-level reallocation. Emergency shelter capacity fluctuated with municipal budgets and charitable giving. Those macro trends are not background color, they are forces that shaped the options available to us. The lawyer's letter was decisive because the institutional scaffolding around housing had become brittle. By mid-2019, the immediate crisis had softened but not resolved. My brother's family had regained a modest stability. The house had been sold. The trustee had distributed proceeds consistent with the trust's terms and paid estate debts. The lawyer had closed his file. On paper the matter had ended. In life it continued. There were still conversations that had not been had. There were still absences to be acknowledged. The legal instruments that had been drafted to avoid crisis had nonetheless precipitated one. The social acts of care that we performed afterwards were necessary but incomplete. We resumed, in fits and starts, the rituals that had sheltered us before, yearly remembrance meals, small acts of acknowledgement, and, when the mood allowed, laughter. I continued to keep duplicates of documents in a metal box and a list on the refrigerator. I continued to call my brother on ordinary days and bring soup when the weather required it. We instituted a modest household practice. Anyone who moved into a relative's home would have a short written agreement, intention, rent expectations, length of stay, so that if the day came when legal instruments had to be invoked, the human narrative would not be the only record. Institutional changes, I realize, take longer. I lobbied for local reforms in small, pedestrian ways, writing to council members about funding for mediation services and advocating for legal clinics to be allocated predictable municipal funds. The City Council convened a Housing Standards Committee in October 2019 and invited public testimony. I testified about the human cost of swift custodial decisions divorced from mediation. The committee did not change policy overnight. It did, however, begin a sequence of public conversations that fed into a larger civic record. Legally, we learned to appreciate the distinction between instruments drafted with compassion and those drafted in a vacuum of human context. The lawyer who had sent that first letter had executed his duties according to law. That competence is not, in itself, a moral exoneration. It is possible to follow procedure and still inflict harm. That fact, that law can be both protective and injurious, should guide how we think about drafting, representing, and implementing legal instruments in families. If trustees and lawyers approach their work with an ethic that included human cost, perhaps different choices would be made earlier in the trajectory. The story continues to move forward. There are appeals and conversations that have yet to be held, documents that are still being interpreted in light of new policy shifts, and small, stubborn practices of care that persist despite formal resolution. In the end, we are left with a dual inheritance: the practical lesson about the necessity of clear, accessible documents and the softer lesson about the irreducible value of presence. The legal architecture shaped a painful episode in our family's life. Our informal practices of care have been what allowed us to remain connected after that legal event. We did not grope towards some simple reconciliation overnight. Instead, we undertook a longer project, reconstructing a capacity to remain present for one another while also insisting that the structures which govern property and trust be drafted with an awareness of the human consequences they produce. The next chapters of this history will continue to test those commitments, and we will have to keep making small choices that may one day add up to something better. The committee work that began in October 2019 did not unfold on a neat schedule. We had expected, naively, that the public record we created would translate quickly into policy adjustments, increased funding for mediation, a pilot program to underwrite short-term legal counseling, and a push for municipal guidance that would encourage trustees and probate counsel to consider human impact before invoking dispossessory measures. Instead, the calendar turned on forces much larger than our city council. In mid-March 2020, the World Health Organization declared a global pandemic, March 11, 2020, and 2 days later the President declared a national emergency, March 13, 2020. On March 27, 2020, Congress passed the CARES Act, which poured money into certain protections and stimulus payments but left large gaps around informal occupancy, cash rent economies, and trusts administered by private trustees. The sequence of dates that had measured the closure of our house, the appraisal, the sale, the distribution of funds, now blended into a new chronology in which public health orders, emergency funding, and administrative delays would matter as much to housing security as any letter from an attorney. The rhythm of our household altered in ways both mundane and seismic. My brother's warehouse, which had been offering him part-time work through 2019, classified itself as essential in March 2020. That meant shifts for him but also new hazards, temperature checks at the gate, changing room constraints that made childcare logistics harder, overtime schedules that sometimes cut into the limited stability we had cobbled together. His wife's evening shifts at the deli evaporated when interior dining shut down, takeout hours fluctuated, and staffing patterns changed with customer demand and safety rules. Their combined earnings dropped in April and May 2020 to a level that made them ineligible for some protections yet too poor to absorb another rent shock. The childcare network that had sustained us frayed in March 2020. My niece's preschool closed its physical doors in mid-March. The abrupt notice came on a Thursday, and in 2 days the program had shifted to virtual story hours and supply packets for pickup. The administrative team that had taken 3 weeks and 2 signatures to transfer her enrollment in 2018 now faced a different bureaucracy, emergency licensing questions, teacher redundancies, and uncertainty about federal relief for early childhood programs. We kept the drawing family is more than walls on the refrigerator, anachronistic against the pandemic posters and grocery lists that suddenly proliferated. Legal and institutional responses multiplied but did not always reach us. In late spring 2020, local municipalities enacted temporary moratoria on evictions, and the federal government's CARES Act extended certain eviction protections for tenants in properties with federally backed mortgages. These measures created breathing room for many but left blind spots. Our experience had shown how vulnerable occupation without documentation could be, and the moratoria assumed a nexus of landlord-tenant law that did not map neatly onto disputes driven by trust administration and estate liquidation. Local legal clinics, already underfunded before the pandemic, were overwhelmed. The pro bono attorney who had once scrolled through our brother's sparse receipts now found himself giving hours in the middle of the night to clients whose deadlines had been accelerated by court closures and limited access to clerks' offices. We learned, with a kind of weary clarity, how distinctions in paperwork mattered more than they should. Unemployment systems strained under unprecedented filings. My brother attempted to file for benefits for weeks in April 2020. His part-time status created complications around eligibility and back pay calculations. The first stimulus payments, executed in April 2020, arrived but did not bridge the months of lost income. On a practical level, the pandemic amplified the same legal fact that had been true in 2018, absent a written lease, absent utility accounts in your name, absent receipts with clear dates. Your claim to a home becomes a story at risk of being discounted by institutions that measure legal entitlements in forms and ledgers rather than memory. Community responses sprang up. A mutual aid group in our neighborhood organized food drops in late March and April 2020. A church that had offered 1-week lodging in December now coordinated rotating shelter for families who were medically at risk. Volunteers mapped available resources and circulated lists. Which landlord was still accepting rent installments? Which agency could expedite documentation for housing vouchers? Which legal clinic had a waiting list but might accept emergency calls? These acts were not policy, they were improvisational social infrastructure, necessary but fragile. I continued to write to and meet with council members. The Housing Standards Committee that had convened in October 2019 resumed hearings in January and February 2020, but then pivoted to pandemic emergency measures in March. Public testimony shifted from a focus on fiduciary practice to immediate requests for rental assistance and eviction diversion programs. Municipal budgets tightened and then, with federal intervention, loosened in new ways. In March 2021, Congress passed the American Rescue Plan Act, March 11, 2021, which opened a channel for cities to receive funds for rental assistance and other emergency supports. That infusion mattered because it allowed, in mid-2021, for legal clinics and mediation centers to receive predictable municipal funds they had lacked in 2018. The sequence from advocacy to fund allocation was uneven and slow, but the dates mark a pathway in which the civic conversation we had begun in 2019 intersected with federal spending decisions 2 years later. We saw both immediate mitigations and persistent gaps. The city launched an emergency rental assistance program in late 2020 and scaled it in 2021 with ARPA funds. Application portals required backrent documentation and landlord cooperation. Those bureaucratic conditions, ordinary in a more functional system, reflected exactly the friction that had undone us in 2018. My brother and his wife applied for assistance twice in 2020 and again in 2021. Each application required invoices, signed leases, or ledgers of payment that they either did not possess or could produce only with the help of long-retired landlords or neighbors with shaky records. In September 2021, a community advocate helped them marshal affidavits, pay stubs, and bank logs. A payment arrived that winter that covered several months of arrears and prevented yet another displacement. That payment did not restore what had been lost in 2019, the antique clock, the continuity of a home, but it prevented the immediate destabilization that had led to shelter risk. There were moments when law seemed to catch up with compassion. In 2020, the local bar hosted a panel on fiduciary duty and human impact. Who sat at that table included estate attorneys who had never before considered the downstream housing consequences of trust liquidation. The conversation was not yet policy, but it seeded awareness. Advocacy groups pressed for protocol. Before a trustee sends a vacate letter, require an assessment of reasonable alternatives, a cooling-off period, and a notice of referral to mediation. These reforms remained proposals for months, and some were adopted only in pilot form in 2021 and 2022. The community had to fight for tiny increments, small mediators' rosters, a list of trained volunteer probate checkers who could advise trustees, a municipal guideline encouraging trustees to consider short-term accommodations for family members without formal tenancy. Incremental changes, yes, but in a system where dates and filings often decide outcomes, incremental changes alter the chronology of dispossession. Family life adapted alongside these public shifts. We formalized practices we had first sketched in 2019. Anyone who moved in with relatives now signed a short written statement of understanding, intended duration, contribution expectations, and a mutual plan for documentation. The act of writing down our intentions felt both bureaucratic and humane. It made us think about contingency, what records would be needed if a legal mechanism arrived, and about dignity. My brother, who once balked at discussing rent in precise terms, came to appreciate that the clarity of a document could offer protection that goodwill alone could not. There were personal anniversaries that the law could not reach. On the third Sunday of March 2020, the Sunday my grandfather had once wound the antique clock, I found myself turning an empty key on the mantel where it had sat for 30 years. The clock was now an estate asset. I have never seen where it went. The absence of that ritual object marked a psychological ledger I could not balance with any municipal reform. Memory remains non-fungible. The legal battles never felt entirely closed. Appeals, administrative reviews, and the slow churn of bureaucracy continued to open new dates on our ledger. My brother appealed a denial of certain benefits in late 2020. An administrative hearing was scheduled for February 3, 2021, and then postponed twice due to court backlogs. Each postponement accumulated stress. On the other hand, the presence of a municipal rental assistance program by mid-2021 meant that when a landlord threatened an informal occupant in August of that year, advocates could sometimes avert displacement that would otherwise have resulted in the kind of sudden eviction letter we had once received. The institutional scaffolding had been strengthened, unevenly and belatedly, but strengthened nonetheless. The pandemic made other dynamics visible. Housing markets surged in many neighborhoods even as employment remained precarious for service workers. Between 2019 and 2021, rental rates in certain corridors increased again, pressing low-income households toward the margins. Landlords who had once been willing to accept cash arrangements became more selective. At the same time, Philanthropic resources and federal funds expanded the capacity of legal clinics to take on eviction defense and to train volunteer attorneys in housing mediation. Those changes matter because they alter the probability that an informal occupant will meet an advocate before a letter is mailed. Our family's rituals continued to be a form of lawless protection. Neighbors watched my niece, friends lent furniture, someone sent a check anonymously to cover a late fee. These acts are not scalable policy, but they remain the human bulwark against the fine print power of legal instruments. In late 2021 we began to formalize some of these mutual aid practices, creating a neighborhood escrow fund administered by a church board to cover 1 month's rent for families facing sudden loss of income. The fund is small and its governance cautious, but it exists as a literal translation of the idea that, before the law does its work, communities can intervene. There were moments when legal actors acted differently because of the public conversation we had seeded. A trustee in a neighboring estate case in 2021 agreed to a 90-day relocation plan for a decedent's informal occupant rather than a demand to vacate. The trustee cited community pressure and consultations with mediators. That case is not my family's, but it felt like a small proof of concept. Public testimony and sustained advocacy can alter practice. The change was not systemic, it was scattered and dependent on particular people making discretionary choices. Yet even scattered choices, when aggregated over time, shift the lived chronology of dispossession. Dates change. Hearings get postponed in favor of mediation. Letters become offers of assistance rather than ultimatums. Still, the underlying legal architecture remained stubborn. Trust documents continued to be drafted with ordinary fiduciary clarity and little humanistic annotation. Trustees' obligations, to protect estate assets, to minimize creditor exposure, to document every action, stood firm. Those obligations are not malicious, they are legal imperatives. The difficulty arises when the instruments that execute those duties are designed without contingency for common social realities. Adult children who have occupied homes without leases, elderly parents who require caretakers, and households that have relied on cash economies. Those realities continued to collide with legal process in 2022 and into 2023. We sustained an ongoing project of civic engagement. I continued to testify at council hearings, nudging the city to require mediation referrals in estate-related occupancy disputes. The Housing Standards Committee produced a report in late 2022 that recommended pilot programs and a standing fund for eviction diversion and probate mediation referrals. Implementation timelines were set for 2023. These were technical things, budgets, ordinance drafts, interagency memoranda, but they mattered because they created concrete dates and procedures that could, in time, change outcomes. On a household level, the ledger of dates kept expanding, but with different contours. There were new filings and hearings and administrative reviews, yes, but there were also birthdays celebrated with fewer guests, a kindergarten graduation lived partly online in June 2021, and the slow accrual of documents, a landlord's signed lease in September 2021, bank statements filed with the Housing Authority in November 2021, and a successful emergency assistance payment in January 2022 that bridged a gap and forestalled eviction. Those entries are unremarkable on paper. To us they were a reprieve. We learned that reform is often an exercise in patience and persistence. The immediate harm inflicted by a letter marked "Vacate the room" in September 2018 did not vanish with single policy adjustments. It required sustained attention to the administrative details that translate legal rights into lived security, accessible mediation rosters, predictable funding for legal clinics, simplified documentation requirements for emergency assistance, and protocols that encourage trustees to consider human costs before initiating dispossession. Each of these elements has its own implementation calendar, its own fiscal years, and its own politically contingent votes. As 2023 turned into 2024, the city had adopted several modest changes recommended by the Housing Standards Committee. There was a standing referral mechanism for mediators, a pilot escrow fund for emergency relocations, and a municipal requirement that trustees provide a notice of alternatives before initiating certain dispossessory processes. None of these reforms neutralized the power of law to enforce property rules, but they altered the sequence of events that had once been so swift and decisive. They inserted phases in which human narratives, supported by mediators and advocates, could be presented and considered before a lock changed. My brother's life, like the city's policies, continued to be a work in progress. He moved in late summer 2023 to a unit with a written lease. The security of that document was the result of careful budgeting, a steady job at a different distribution center, and the support of a mediation program that helped him negotiate terms with an accommodating landlord. It was not a restoration of everything we had lost. The family meals that once took place in the house sold in March 2019 remained uneven. The clock remained absent. But there was, in September 2023, a lease with signatures and a tenant portal login. Small legal artifacts that altered the probability of future displacement. Our civic work continued to fold the private into the public. We pushed for clearer plain language notices in probate and trust administration, for expedited referral lines to housing advocates, and for municipal auditing of outcomes in cases where dispossession intersected with family caregiving. The arguments were technical at times: amendments to municipal codes, budgetary line items, procurement language for mediation services. But each technical amendment was an attempt to bend the calendar in favor of deliberation. There is no simple moral ledger that balances harm and remedy. The law will continue to do what law does: provide mechanisms to resolve property interests, to manage assets, to discharge debts. What changed, incrementally and unequally, was the sequence in which those mechanisms are now applied in our city: a small cooling period in some cases, a referral to mediation in others, and a modest pool of funds to cover emergency relocation where necessary. Those changes will not prevent all harm, but they alter the choreography of dates that once turned a family's story into a sudden dispossession. We continue to keep records in a metal box and lists on the refrigerator. We continue to insist that simple documents, signed statements of occupancy, receipts for cash payments, utility account transfers, are the small protections that can prevent larger harms. And we continue to press for larger institutional changes: predictable funding for legal clinics, mandatory mediation referrals in certain probate cases, and public education campaigns to make clear the hazards of informal occupancy. These efforts are slow and often unglamorous, but they matter because law is, fundamentally, a sequence of actions that unfold over time, and altering that sequence can alter outcomes for families like ours. The next chapters of this history stretch forward in dates that are already being written: pilot program evaluations due in mid-2024, a municipal audit planned for September 2024, and continued hearings on ordinances that might, in time, make the difference between a vacate letter and a mediated agreement that buys a family enough time to stabilize. We are not confident that these changes will be sufficient. We are, however, convinced that if enough small interventions are stitched into the institutional fabric, if lawyers, trustees, municipal actors, and neighbors repeatedly choose deliberation over immediate dispossession, then the calendar that once produced a crisis on a single September morning might produce instead a sequence that preserves both legal integrity and human dignity. By spring 2024, the pilot programs had begun to produce paper trails of their own: quarterly reports, case summaries, and busier calendars for pro bono attorneys. The mid-2024 pilot evaluation scheduled in June looked outward and backward at once, cataloging which interventions had produced breathing room and which had merely delayed the same legal rhythms that had produced our family September 2018 crisis. Mediators reported achieving mediated transition plans in a number of probate-adjacent cases. Housing advocates documented instances in which the new referral mechanism bought weeks, sometimes months, for families to apply for assistance or to secure a lease like my brother's in late summer 2023. At the same time, evaluators noted stubborn failure modes: cases where trustees, constrained by fiduciary conservatism or by creditor pressure, still moved toward swift disposition. Those failures reminded us that policy can change sequences without dissolving the legal imperatives that drive many trustees' decisions. The municipal audit planned for September 2024 would, we hoped, measure not only outputs, how many referrals were made, how many mediations convened, but outcomes: who remained housed after mediation, who transitioned to stable tenancy, and who nonetheless received a letter that felt indistinguishable from the vacate the room demand we received in September 2018. The audit scope felt intentionally modest, a review of procedure rather than wholesale transformation. Still, the existence of a date on a public calendar for this evaluation mattered. It meant that municipal actors would be accountable in a time-bound way, and that advocates could marshal testimonies and case files, those metal box records, the receipts and signed occupancy statements on the refrigerator, into a body of evidence before auditors opened their envelopes. Hearings on the proposed ordinances continued through late 2024 and into 2025.